Good afternoon, everybody. First of all, it's our pleasure to be here today, and many thanks to American Chamber to arrange this event. Carrying on the introduction about Hammouri and partners by Ms. Noor, CEO of Citibank, I would like to expand the introduction about our law firm. As our law firm was established in 1994, Hammouri Partners has three main departments, various established desks, and currently we have a team of 32 lawyers and professional personnel in our law firm. Now, in terms of our main three departments, I will talk about them briefly. The first department is the litigation department. Our team in this department is very experienced and has a proven track record of case handling throughout Jordan, and the team can successfully handle all litigation and arbitration matters that corporate client may encounter. At the same time, in that department, we have three desks. The first one is the general litigation and arbitration desk. The second one is the banking litigation desk, and the third one is the insurance litigation desk. The second department is the corporate department. Our corporate department team members sit as board meetings with various companies, and they are very experienced in all aspects of corporate matters. We offer to our corporate clients services that are based on good knowledge of compliance with various governmental bodies in Jordan and in updated regulatory standards. The third department is the international department. Our team in this department have wide experience in international trade law matters, including projects, agency and franchising, energy law, letters of credit and guarantee, and direct rates, officer liability insurance. And now I will leave the floor to my colleague, Ms. Yotta, the head of the international department, to talk briefly about drafting contracts. Thank you.
Thank you, Ahmed.
You hear me good or? Okay, perfect. So, good afternoon again. It's nice to see some familiar faces and make new friends. Our presentation today will be in the area of contracts. It's a big challenge when you prepare a presentation on contracts to pitch it to the right level, whether it will be different if you spoke to legal experts, and it will be a bit different if you spoke to experienced businessmen. We try to take the midway and we try to make it short and practical. So, first of all, we need to see what is a contract. We can have a verbal contract and we can have a written contract. This presentation obviously focuses on written contracts because we think this is a more secure way of documenting your business relationship with a counterparty. A contract is defined as a legal agreement. A written contract is a written legal agreement between two or more parties. Under the Jordanian legal system, it is defined in the Jordanian civil law number 45 of the year 1976. The elements of the definition have to do with keywords, which is the parties entering into this agreement at their own free will, and agreeing what they want to agree to be equal and balanced in terms of obligations and rights between the parties. And then we have, of course, the implementation of the contract. This is in a nutshell how we would approach the meaning of contract. Now, a very important aspect that would be useful to talk about today is what would be the skills of a lawyer when you consult him and he will advise you whether reviewing your existing contract which is maybe proposed by the counterparty, or whether drafted, as we say, from scratch. We put here some examples. This is a non-exhaustive list. We said, of course, it goes with the obvious, the sound legal knowledge. Sound legal knowledge, it will be, of course, specialized in a certain jurisdiction. Sometimes you can have a legal expert who is licensed, especially, for example, in the US, he can be or she can be licensed in one or two states. And you can have, for example, an EU lawyer who maybe is EU lawyer or also UK bar lawyer. But mostly, if we talk about the Jordan experience, it would be a lawyer specialized in the Jordanian law. So when we talk about sound legal knowledge, we refer to the specific knowledge which may govern the contract. I will expand in this aspect later. Ability to negotiate, this is something that the lawyer needs, and the businessman needs, and the counterparties need. Good legal drafting skills is very, very important, because in a minute, in the next slide, we will say what are the components of a sound contract. The ability of the lawyer to listen, this is a very important skill in my opinion, to listen carefully to the objectives of the client, to understand what they are trying to secure through this contract, and the ability of the lawyer to foresee future risks. Future risks can be commercial and can be legal. This is just an example, as I said, because this is underpinned always by commercial awareness. A lawyer who is a perfect drafter, for example, you can have an entry-level lawyer who has learned to draft a very, very good contract or use a template, but what would be missing is the commercial, for example, experience and commercial awareness. It always goes together, the legal knowledge with the commercial awareness. Having said that, it's important also to say that the lawyer who drafts a specific contract should have an understanding of the specific sector. So a lawyer who is a prominent expert in drafting, for example, healthcare IP contracts may not be your best choice if he will draft for you a food exports contract. So again, specializing is very, very important. Now we will move on to something which every lawyer, when they start training, they learn, and we use this in all our career, the elements of a contract, of a commercial contract. These are basic clauses that you would expect to find in any contract. Then you come to personalize the contract according to the specific industry that this contract refers to. So it will have extras than those. This is not exhaustive. However, these are always, I would say always, without being absolute, present in a contract. Actually, we divided them, the sequence is not necessarily like this, and I would like to clarify here for the audience that certain jurisdictions have certain style of the sequence, how you present the terms and conditions. And when you go into certain law firms have their own preference on fine-tuning this sequence. Now, let's start with the elements of the contract, okay? Khaldun previously touched on this point, and he explained about the names of the parties. The first thing, obviously, is the name of the contract. The name of the contract, it would be something related to the essence of the contract. However, it is something important here to clarify for all of you here, in case you don't know it, that many clients think that the name of the contract is absolute and will define the what will follow. This is the case. However, you can insert a clause in the contract that the name of the contract and the headings are only for guidance and not binding. So one shouldn't lose too much sleep over the sequence of the wording in the contract. I say this because counterparts from different jurisdictions sometimes have strong views on how to call a contract. For example, will it be a cooperation agreement? Will it be a collaboration on A, B, C, etc., etc. So moving on from the name of the contract, we go to the names of the parties. The names of the parties have a lot of little potential traps that a non-legal person can oversee and can fall into that. A lot of companies have a trade name. We don't want to put necessarily there only the trade name. We must put the official name as is registered in the official authority. So when we have a Jordanian entity, it would be the name. Of course, it will be transliterated, not translated, from the name registered in Arabic. When you would have a foreign company, it will be in English, as most companies are registered if they are in a jurisdiction that is English. Another important point is that we need to carefully draft and explicitly state the registration number and the authority that this party is registered. So in Jordan, it would be under the Companies Control Department, which is part of the Ministry of Industry, Trade and Supply. In other jurisdictions, like in the UK, it would be at the Companies House. It depends on the authority. And so go on. In the US, it will be what the colleague will say, that will join us later from the US. The authorizing is a most important. We have many times, I think there's some issue with this. We have many
Sorry.
We have many times people that are technical people, the head of the section, of the manager, and they sign the contract with the counterparty without having the real powers through the competent authority to enter into this contract. Sometimes, for example, we have a CEO signing the contract, and in the registration certificate, they are not authorized to sign for this amount of transaction, or they are not authorized the chairman, or they should co-sign with the chairman. So, to bring all of this together, what is the advice? What should we do about this in an international transaction? We should ask the counterparty to provide us with official registration certificate of their company and the certificate that would show the authorized signatories. One detail here is that this certificate should not be very, very old, because changes may have occurred. This is in jurisdictions where you don't have access, it is not open access, the company is registered. Because in other jurisdictions, you can just go on for example, the Companies House, and you can enter the name of the company and you see up-to-date information. But in other jurisdictions, the access to the competent authority is with a passport. And usually this passport is given to legal advisors and financial advisors. So this is something very, very important, why you need the advice of a lawyer when you draft a contract. We start from the A. Now, a third element is a provision on definitions. I'm sure you have come across contracts that contain maybe 2 or 3 A4 size pages with definitions. This is, especially in technical contracts, is very, very important. But the important also is that it should be drafted very carefully by the legal expert. If a layman will define certain things, maybe this will cause some issues in case of a dispute with contract interpretation. So it's better to have an expert to advise on this. A preamble. There are a lot of debates in the legal community whether a preamble is needed or not. The Hammouri partners and under Jordanian law, the contracts we draft, they include the preamble. Other colleagues from other jurisdictions don't include the preamble. Now, what is a preamble? It's I would say in simple words, it's a storytelling. It's a storytelling who are the parties, why they enter into this contract, and then it follows with a very standard wording. The parties agree to enter into this contract as explained below, with the terms and conditions. Another important provision or article for the contract is the term and the renewal of the contract. Term is the duration of the contract, and renewal, many people ask, why do I need this? You need this because you may have automatic renewal, for example, 1 year contract, and you want to renew it automatically annually, or you may have a manual renewal. It will expire at the end of the year, and then you insert wording that the parties will only renew it within X period before the end of the term. They send a notice to renew. Why this is important? This is important because in business that you are not very sure about your counterparty, you tend to opt for limited renewal, for short renewal. So you try the relationship, and if it doesn't work, then you are free without having to have some litigation to break the term of the contract prematurely or to incur penalties. Now, we move on after this to the very important provision. I think this is one of the most important, the rights and obligations of the parties. It goes without saying that if you define clearly what are the obligations of the parties under the contract and what are their rights, you minimize litigation risks. You minimize litigation risks, you minimize trouble, and you minimize expenses. And you minimize losses entirely. Then there is the penalty provision. The penalty provision, we have a slide, but we will show you in a minute, so I don't want to go now over this. I just want to run through fast. Exclusivity provision, I just want to, as a highlight here, to say that you cannot, it's very difficult, impossible to get worldwide exclusivity. Usually you limit it to a territory. For example, you, as exporting to the US, you would expect your counterparty not to cooperate, for example, if you opt for exclusivity, not to cooperate with another party within X states, for example, or with 1, 2, 3, 4, 5 states, but you wouldn't make it worldwide because it's impossible. Confidentiality information, we will look in a minute into this in more detail. Expiration and termination, I will go through because I'm aware of the time. I will go through reading this and then I will take you through one by one. Gathering law, financial matters, dispute resolution, and force majeure, and then there are the general provisions. Before we move on to the next slide, I want to speak about the general provisions. What could be the general provisions? There are provisions like assignment or no assignment, the right of a party to assign, to replace themselves in the contract by another party. Severability, this is a standard provision, it is always there. Severability in simple words means if the wording of any clause in the contract is not is found to be unenforceable, or it's badly drafted, let's say, you sever it, you exclude it from the interpretation of the contract. Why this is important? This is important because it doesn't spoil your business relationship. If you don't have severability, it would be annulling the whole contract. Remember, the contract, you invested time, you invested effort, and you invested money in your legal advisors and negotiations with the counterparty. So you don't want it to be spoiled in a second just because a clause is found unenforceable. Now, the pressure actually moves around to this theme, which is the main provisions in the contract. Now we will look, focus a bit more on certain provisions. The first one we put is the penalty. The penalty, we have many clients that ask us, how do we need the penalty provision or not? It depends. There are certain transactions, especially when the counterparty has to complete certain milestones in their performance, and these milestones will affect you receiving this product from the other party. You need to put the penalty provision. The penalty provision, the advantage is that it has many advantages. One is psychological advantage, okay? When you know you will be penalized by X amount for the breach of said obligation, you are very careful, if logic goes, to avoid incurring this penalty.
Excuse me.
Yes.
Now I know that penalty clause is not allowed in some countries. They replace it with liquidated damages. That means you are not allowed to do any penalty clause in the contract, that you use liquidated damages and you pre-estimate how much the liquidated damages that can happen.
Yes, this is one way of dealing with
correct?
a breach. This
Yeah.
is one way of dealing with a breach. Another, this is valid in certain jurisdictions, as well as there is valid in other jurisdictions, certain jurisdictions, that the amount of compensation should not put the party that receives the compensation in a better position than the party was prior to entering into this deal. However, under contracts we draft, we can get a consensual penalty clause, which both parties agree that it will be X or Z. Now, let's say the parties agreed the penalty, and let's say there is a breach under the contracts governed by Jordanian law, and I will explain later specifically about the exports and imports about the governing law. But let's say the parties get a penalty clause, it is a consensual penalty, and you go to implement it. And let's say that the party that has to incur the penalty, let's say, does not pay the amount, and you end up to court. In that case, the court, the Jordanian court, will assess the penalty, and they will determine whether it was fair and just, or whether it is out of being fair and just, and they will adjust it accordingly. Now, the court decision will be what will be binding for the party that has to pay this penalty. So, there are many different stages in a contract how you deal with a penalty. I don't know if I clarified what you are asking. The answer is, in a nutshell, that Jordanian contracts governed by the Jordanian law, you can put a penalty provision. However, one should bear in mind that if the other party disputes, although it was consensual in the agreement, they can go to court, and the court will either confirm this amount or ask set a new amount.
Yeah, you answered my question actually. In Jordan law, they allow the penalty clause, right?
Yes, it is allowed. But with what I explained now, the conditions that I explained, actually we'll show you a slide about the Jordanian. I mean, after this, we have a slide which is this, determining the value of the penalty. And my colleagues assisted me here, and they put the clause from the civil law and Article 364 that is explaining just what I said now. This is just what I said now, but it is a bit more in more detail. Okay. The most important from this slide to understand is that if the penalty is disputed, the court, and if we have, of course, court dispute resolution, the court will decide, and what will be decided will be binding to the parties. Of course, in the legal system, you can go into appeal, and so on till you take a final decision. Now,
if the penalty is not reasonable, it can go to unfair contracting, right?
Yeah, you will go to court, you will challenge it, and the court will either confirm that it is reasonable according to the opinion of the judge, or not confirm that it is reasonable, but what it will be decided will be binding between the parties. We haven't come across many challenges of penalties. Usually the parties, when they negotiate, they agree what is fair, and challenging the amount of the penalty usually happens in pre-contract negotiations. So when you reach the contract, it is with the consent of both parties. So usually you don't see disputes, at least with the commercial contracts we dealt with. Now we need to speak about the confidential information. This is something that is overlooked in the contract drafting. Sometimes you don't even see it being there, but it's important. Why is it important? It is important because in any trade transactions, you will disclose potentially confidential information. What do we mean by confidential information? We mean something that is not in the public domain. For example, is not announced in your website. Okay. Or we mean something that is related to a trade secret. So we put a clause there to protect and to dictate and to detail how you will use the confidential information. Usually the confidential information binds the parties, the two parties, and usually there is wording. This is a very simple clause we put there. It's a very, we wanted to demonstrate the difference between a very simple clause, which is fine as it is, and a very complex clause. A complex clause will talk about specific professionals that can have access. For example, you can name not only the employees of the contracting party, but you can name their accountants, you can name their lawyers, you can name their advisors if they will help with some due diligence, and so goes on. Something important about the confidential information is that it is one of the clauses that survives the end of the life of the contract. So when you are bound by confidentiality, of course, you can either make it indefinite or with a certain duration. Most clients prefer indefinite to protect their trade secrets. One must know that, let's say your contract was 1 year duration, and it expires at the end, last day of this year, and you don't renew. That does not mean that to say, okay, I finished with this counterparty. The contract, I put it in my drawer and I forget about it. There are certain clauses that survive as an obligation on the parties. The confidentiality clause is one of these clauses. So even if you terminate, you still have the duty, the obligation under the contract to safeguard the information and not to disclose it to the wrong parties. This is very, very important when we talk about competition in the business market, especially when there is no exclusivity in the contract. This is very important to have a clause that dictates how confidential information will be dealt with. Now we will move to something which many clients, many businessmen ask us about. Sometimes the distinction is not very clear. We have two terms. We have expiration of a contract and we have termination. Most people, when the contract ends for whatsoever reason, they use the term termination. Ends, termination. Actually, from a legal perspective, the two terms are not the same. They are different, and they should be explicitly stated in the contract. In a simple way, if we talk about expiration, expiration is the natural end of the contract's life. So if the term would be 1 year, expiration is by itself, it will stop being in force and existence at the last day of this year. On the other hand, termination is not something that happens naturally. Termination usually happens either at the will of both parties. They decide, for example, they worked for 1 term, they entered into a second term, and they do not wish to. Maybe they found a better partner, or for what other reason, commercial or not. Then we have termination of the contract. Termination can happen also, of course, it would be this explicitly stated in the contract, when we have a breach that is so material that will make the contract impossible to continue. Now, we can have another way of termination. Sometimes we don't see it much in practice before, but maybe now with the pandemic we can see the application. It is when one of the parties is unable to complete their obligations due to a force majeure. We will look into a force majeure in a minute, but this is obviously, as the word says, it is something that is imposed on one of the parties. So then we have a termination. Now, we put here that after the contract is terminated, the parties are free from each other. However, one must know that the liability that occurred before the termination is still on the parties. What do I mean by this? Let's say we have a termination at will by the parties, and you provided some goods to the counterparty, and you are waiting for your invoices, and your invoices are payable within 28 days, for example, after the termination date. That does not mean because you terminated the contract, you terminate your obligations. The obligations that occurred previously and the rights are still valid to be fulfilled, even contract. So I think this is something very, very important in terms of performance and in terms of contracts. Another detail about this is when we talk about renewal. Renewal, we talked about automatic renewal, but we can have also a renewal when parties serve a notice. Usually, the parties agree that the renewal, obviously, one has to appreciate that things cannot happen instantaneously. So, what is important in the renewal is that there is a period, a warning, let's say, in advance that you intend to renew, and the other party to accept this renewal. We believe that a skilled lawyer should follow up with his client to remind him about the renewal opportunities, because sometimes if the renewal notice can be served 30 days before the end of the life of the contract, and you miss it, and you remember it just 1 day before, you are out of what the contract stipulates. I think all these details, of course, now we talk on a theoretical level, and it's sometimes not easy to remember, but when you implement it in practice, they all make difference to your business, and business is money, so they make difference to your money. So we should take care of it. Now, we are moving to the next slide, which is very important. Actually, so far I consider all the slides as you see very important. But this is something that many people, and even from the audience today, asked some questions. Dispute resolution. Now, if you, as Khaldoun said before, if you have your deal on a purchase order, you will cover maybe financial, you will cover the product, but you will not cover the dispute resolution. Dispute resolution is put to be stated in the contract, and obviously most people think of dispute resolution as court resolution, or some people think of arbitration. Well, one thing is for sure, you can either have court or you can have arbitration. You cannot have both. Now, before you, let's say the parties agree for court or for arbitration, what are the factors to decide whether you want to have your contract governed by court, dispute resolution, or arbitration? One very important factor is, of course, how much you trust the legal system of the applicable law in the contract. Another important factor is financial, and of course the wishes of the parties. Both parties have to agree. If you, let's say, before the contract, before you reach the dispute resolution mechanism, how you can manage your dispute in an effective way? You can manage it in an effective way by putting what we call amicable negotiations period. This is much better because maybe with discussions with the other party, you will avoid going to court or to arbitration. So you dictate, for example, you can make an escalated procedure. For example, you can say that if the parties have any disagreement, first the two heads of the technical can come together, the guys that made the deal. Then he can be escalated to CEO, then he can be escalated to chairman. Now, this is all lovely, but it's not so lovely if you leave it open, because you can negotiate forever and you can incur losses already for the breach, for example, and it's not very good. So how you make this safer? You put a time frame and you specify and you say, for example, the technical guys will negotiate for 1 week, then it will go to CEO for another week, then it will go for a few days or for 1 week. Usually you put it to the chairman, then it will go to the applicable resolution. Always, if you opt for court resolutions, the court always wants to see evidence that the parties, before knocking the door of the court, they have tried to resolve it amicably. So it is very good to put like this. Now, there are some other ways. One is conciliation and one is mediation. We move away now from the parties. We go to a third party. You can have, we will show you in the next one, you can have a conciliation and you can have a mediation. Conciliation and mediation have slight differences. At the end, the result, you can register it at the court. unless also you go for a recognized body, for example, the ACAS in the UK, they have professional mediation, and they give you their support in this. In Jordan, the rules of mediation are organized by the mediation law for the year 2006, number 12. So relatively, this is new. If you think of the year of the Constitution, this came later. Now there is a trend in the contracts to use what we call ADR, Alternative Dispute Resolution. This means alternative to what? Alternative to court. You may use an institutional arbitration. There are many bodies of arbitration. For example, the London, the ACIA, there is the ancestral rules from the United Nations, there is the ITC that we saw before. There is a very interesting for the Middle East doing business, the center in Dubai, the DIFC, that is a joint venture between the LCIA from London and the DIFC. And so goes on. In Jordan, there is actually arbitration, and there is law governing arbitration. It is the Jordanian arbitration law for the year 2001, and we have arbitration in Jordan. And we encourage our clients to seek arbitration in Jordan, even if the counterparty is a US counterparty, because actually it is, in many cases, it works out cheaper than the institutional arbitration. Having said all that, when you reach the award of the arbitration, it's not the end. We have many clients that they come to us and they say, I won a case in arbitration, ICC, I don't know, in London, in Paris, whatever. I won, and now I will take $500,000 from the other party. No, it's not like this. We have to follow another stage, which is called enforcement, recognition and enforcement of the foreign judgment. What does this mean in a simple way, in a simple manner? It means that you take the award from the ICC, let's say, body, from the arbitration body, and you enforce it at the court where the counterparty has legal presence. Having said that, you may be able to enforce it not only where they are registered, but in a place where they have assets. For example, you may have a USA company, you may enforce it, for example, in the state of Delaware, but through diligence, you discover they have assets in London. You may seek to enforce it there. So then there is a little stage that goes through the court system of the place where you enforce it. But what is the advantage of this? It is not a new case. It is a case that you recognize, the court will recognize the award. Of course, there is the New York Convention, and a certain number of countries are members, others are not, and there are certain conditions to be met. One of them, I don't want now to take time because we are after the break, and always it's very heavy after the break to focus on technicalities, okay? For speakers and for audience and for speakers. So, what is very important and thank you very much for the support of Amcham, giving us a bit of water, thank you. The important, one of the most important elements, without going into technicalities, the award, the arbitration award must be final at the place where it has been issued. What do I mean final? It goes through the first decision, it goes through appeal if it is appealed, and there is nothing that can happen in this legal system or very important. Obviously, all this requires certain effort and it requires certain expenses and it requires time. That's why we focus on the importance of having a very well drafted contract. We left last the point about the force majeure. This is a clause that many people, technically in business, didn't pay much attention to prior to COVID. But certainly with COVID, all the legal experts were reviewing it, and there is a lot of fora, international and e-meetings, and I had the pleasure to participate in one between businessmen of China and Switzerland, and we were all taking, this was whilst we were working from home during the restriction period, okay? Still now there is some uncertainty. I will explain what it is. Okay, now, force majeure. Force majeure in a nutshell, it means we have something that the parties, that happens unexpectedly. It is beyond your powers to control. In a nutshell, because certain jurisdictions put the element, put the party foresee it or not foresee it. I don't want to go into this. Let's say it happens unexpectedly. The definition before, pro-COVID, it was that it includes generic wording, acts of God, meaning unexpected, okay, and certain other things which happen beyond your control, for example, natural disasters. Now it opened a new chapter in this, and the businessman must be very careful, of course, according to the governing law, on the wording used for the force majeure. This is a wording we put, it's only indicative, by the way, you can modify it. We put after we saw the events in Jordan. In Jordan and in other places, we should focus a little bit on this. We had force majeure clauses but included keywords. They didn't include including but not limited to. They stated the events that constitute a force majeure. And yes. Yes, absolutely.
Okay.
Yes, but please, after I complete
No, you know what I mean.
Yes.
It's an incorrect interpretation.
Please, tell us your
No,
opinion.
because there's an indicative list and there is a clause list. All the force majeure, because of the nature of the term, they are indicative. If you interpret them as clause, this is an error in law and fact.
Absolutely.
Because the force majeure is a general principle of law. Even if there is no term in the contract, I can refer to it. So this is an incorrect interpretation. Sorry.
What is the
I think
you mean?
To have a clause, it's not a clause list. It is
No, it is not a closed list. But the topic is not whether it's a closed list or not. The topic is the key words. The previous force majeure included, please, and we will provide you with an analysis of this. Included pandemic, included epidemic, and this is worldwide in many clauses. Some courts took the approach that the word epidemic is not enough to cover the word pandemic. So
it's not the pandemic or epidemic. It is the issue of how is it a force majeure or is it something that's temporary? This is the question.
well,
It's not the
force majeure,
how temporary is it?
the force
What is the function itself?
yeah,
So
but
you
the
can't,
force
so if I work from home, I can't say force majeure. It's not like an earthquake. It's very specific. These are the interpretations that come to play because it's not a ruler. Because some contracts can be implemented even if it's because of the nature of the pandemic.
correct, that's why I said to continue. Let me just give me 1 minute.
Oh,
So
sorry.
the force majeure does not mean automatically that your contract is terminated. You see, always the legal experts have different approaches in certain topics. But the force majeure is not something that happens to you and automatically you stop your deal. The force majeure usually gives a correction period to the other party to resume their obligations. And the force majeure usually does not exclude you from financial obligations for something that you should receive. So we call the step Lana, the contract is not automatically always terminated with a force majeure. There is a period for correction for the parties for breaches that can be rectified. We have breaches that can be rectified and we have breaches that cannot be rectified. I don't see a real disagreement. Maybe your approach is that to state that the force majeure is not a closed list. No, it's not a closed list. We all agree on this. But what I'm saying is recently in the Jordanian jurisdiction, there was taken the approach of do you need that keyword pandemic? Or if it says epidemic, it will be treated as a force majeure. And it happened that, so the advice as Hammouri we give, and we get this already, is that we should explicitly include keywords. And we will show you an example after this, the next slide, about the defense law, how you make something, because the defense law is Jordanian law to cover the pandemic. So we will show you in the next slide. This is a wording we use to cover the defense law. So,
Excuse me.
yes.
Now, for force majeure, I had a problem with one supplier because of his factory broke down. He said it's a force majeure. Now, would it be advisable to define what is force majeure in the contract?
First of all, you will look into the applicable law of the contract. The applicable law of the contract is what?
Say Jordanian law?
Say Jordanian law. So it will go under the Jordanian law interpretation. And
Without defining?
Well, if you will go to the court will decide. But there is, as I said before, there were many cases, not just one case. There is many cases, for example, with hotels, whether they would be open during the pandemic or not open, whether they would have few employees to be considered they are working or not working. And different jurisdictions took different approaches. And there is no clear answer to whether the specific circumstances it goes to court and the court will decide.
So it's not always the act of God, right?
Well, this is what we mean about act of God. It is not just act of God. It is many events that cannot be, you don't have a control over them. What is act of God? Act of God, for example, is an earthquake. But you can have other events which are not act of God. They are act of government. For example, you can have a financial institute lockdown, as it happened in some jurisdictions years ago, in Europe, for
Take
example.
one example is that the factory broke down for any reason.
Yes, but we need to look into the specifics of each case, whether the factory broke down or the pandemic, you mean, right?
Yeah, of course.
Yes, we need to look into the specifics. We cannot just give an answer A, B, C for the force majeure. We look into the details of it, correct? And Mr. My presentation is starting to an end. I don't know if there is any question or Lana, you need to add anything.
I want to give an example. The force majeure is poor partner, meaning that it is something outside the control of my control, but that I am unable to address it. So there's like act of God, but not any act of God. Like if it's let's say it rains in Florida and the place is in New York, in America, it has to be specific. All of force majeure is a case by case. You have to claim force majeure. It could be war, it could be right. And the question of the pandemic, why it is so critical? But it is the question of force majeure is case by case. Because, and depending on the type of business. Another example, the reaction of the force majeure, what's happening now with the shipping container and the delays and some exporters
And is this force majeure? This force majeure?
Export and the prices have quadrupled is an understatement. So is this a force majeure or not? It is, we can discuss, this is a question that the parties can agree on, or they can go to court to adjudicate it, to weigh. Can you reasonably react to this or not? In one sense, you can say, but you can ship by airplane or whatever, but that will cost too high. So this becomes where the court will come to take. That's why when we talk about the pandemic, the force majeure question is very it's not time sensitive, it evolves with time. So in the beginning, you say, yes, this is a force majeure because of the lockdown. But the day after, it's evolving with time. So how long can you claim the force majeure? And how does it affect? Does it freeze your obligation? Does it give you time can you adjust your obligation? These are all questions the parties are just able to address. And
now, if I put in the contract, it is the delivery is the essence of contract, right? And he claimed that there is a delivery period and there is a short of containers. Would this be a force majeure?
And in my opinion, it is a force majeure, but it is something you can correct. You can correct, so it does not dissolve your contract per se. but it makes it hard. We have to negotiate. It gives you standing to renegotiate.
But if I put it the essence of the contract, for example, if I am participating in a tender,
حتى لو ما في force majeure in your contract, you can always claim force majeure. Correct me.
I think we should leave you and we should do the presentation and then open the floor to discussion.
I want to add one more point about to complete the pandemic topic and all this discussion. The biggest discussion at the moment, the largest discussion at the moment in Jordan on what means Lana, maybe we have some small disagreement, is in the insurance sector. The insurance companies in Jordan are consulting big way the law firms, including our law firm, because we represent 50% of the insurance sector in Jordan, on how it can be dealt with the pandemic. And I can tell you that the line is that if the keyword pandemic is not explicitly stated in the force majeure, there is a way for the insurance company to use this argument to escape from the fact that, for example, there is epidemic. And then who will decide, Lana, not we, not you, but the court?
I agree, but you have an opinion, no?
Yes, sure.
I think the conflict of interest will
yes, we have some conflict of interest, but with Lana, we're dear friends also, so...
and what we need is, what should we put in the contract, right?
Well, yes, but what we started today, Mr. Osama, you need to come to see it. Okay, I think I finished. I want to announce there is more from Hammouri. There is my dear colleague Omar of Ayyash. He will take you into a different aspect of your transactions in the US, which is IP, intellectual property. So thank you. And if there is any questions,
hello everyone. Thank you for being here. It's my pleasure to be here.
شغال.
We're running out of time. I'm not sure I can finish within 2 minutes, so I don't know what to do. We have 2 more minutes.
I think we have done it right.
Not yet. We can
try. Let's keep going, and because it's 8 o'clock in the US, so we hopefully we'll give her a bit of leeway.
As you can see, we're going to have an overview of trademark registration in Jordan and international media system. So we decided to talk about trademarks. We decided to talk about trademarks because trademarking is an important step for protecting your brand identity. Because it will stop your competitors from taking your customers by using your brand. It can also protect you from those copycats, let's call them, from damaging your reputation and product. Now,
Okay.
so to begin with, Jordanian law. So the Jordanian law regarding trademarks is created under the Trademarks Law of 1952 as amended in 1999. The Jordanian law defines trademarks as visually perceptible signs used by any person for distinguishing the goods or services from others. Now, Jordan is a first-to-file jurisdiction. This means that whoever goes and registers their sign or mark first, they will have the right over it. And registration is mandatory. So if you did not register your marks, you will lose, most probably you will lose the right over it. So to determine that you have the right over the trademark, they will conduct formal registration or formal examination over your application, and they will provide as well, they will conduct a distinctness examination, which is applied in a manner that to check whether it secures distinguishing your products from other products. Now, they would look at things like letters, names, numbers, figures, colors, to check if your application and your trademark is distinguished from others. The period for registration in Jordan, it will take up to from 8 months to 12 months. And it will be published at the Patent Gazette in Jordan. Registration of a trademark will be valid for 10 years. After the expiry of this period, you have a 1 year to renew your registration. You have the first right as the owner of the trademark to renew your trademark ownership. It's worth mentioning that if you did not use your trademark for 3 consecutive years, you will lose the right over this trademark and will be considered as unused. The MADRID system, I'm not sure if you've heard about it, but it came to existence by the MADRID agreement and later by the MADRID protocol. It's a system that is used to register your trademark internationally in over 124 countries. The idea is that it's an easy platform, convenient and cost-effective, that you use one application, one set of fees, and accordingly you can register your trademarks and you can go worldwide with your trademark.
And how long would that registration? The period to complete the registration.
So the period for registering the trademark, it will take from 12 to 18 months. Depending also as how many countries you want to register in. And the registration will be valid for 10 years and renewed again for another 10 years. So if we look, Jordan and the MADRID system have the same criteria, maybe, because Jordan has adapted the criteria and the requirements of the MADRID system, but it hasn't implemented it and executed it nationally.
So basically, you need to state what countries you want to be registered in. You will not be automatically registered in 100.
Yes, you have to choose which countries, because the more the countries that you want to register in,
the more the fees.
The fees as well, yeah.
And the same applies of the 3-year, not
No,
it doesn't apply.
it's more flexible.
Thank you.
So as we said, it's a one legislation covering multiple territories, between 12 to 18 months to register the application. So it's just to show you, this is the countries that have implemented the MADRID system. Shows you how important it is. You can see
None in Europe? None in Europe?
All Europe.
Also, it's the other way around.
Yeah.
So it's the blue. Okay.
So you can see it's all Europe, the US, Brazil, Colombia. When it comes to Arab countries, we have Morocco, Tunisia, Algeria, Egypt, Sudan, and Oman, and Syria. But you don't have Jordan. The UAE has. This is the Halafi, you can add.
Jordan,
But you have like Jordan, as far as I understand, they were gonna implement the agreement and execute Jordan, but due to the pandemic, it was
Force majeure. So basically, you can apply according to the MADRID system, although Jordan has not joined.
No, you have to be able to apply according to the MADRID system. You have to be either a resident of these countries, you have a company or a commercial business there, or your country is a signatory to this.
So just bear with me. Let's take the scenario of Hammouri having an office in any of those blue countries. Can a Jordanian company apply to the MADRID system through your offices?
Yes, we do that, but we do it via affiliate law.
Whatever.
But to be, again, so if a Jordanian company, to be eligible to this, it has to have a commercial business there.
Presence.
Yes, any sort of presence. Residing there, or they are nationals for this country.
In the country where they are applying from.
And you have to apply there for your trademark to be registered, and accordingly, or simultaneously, you can apply for it.
Understood. Thank you.
Sir, as far as I know, that it's not necessarily if you want to register a trademark in a particular country, that you will have an active business there. You can still protect your right by reserving your trade name or trademark by certain countries that you choose and you pay your fees.
Yes, true, but it's not via the Madrid system because this is the criteria for the Madrid system. So you can easily go to the US and register alone, not via the Madrid system.
Okay, can you tell me the difference between the Madrid system and the non-Madrid system?
Of course. So if you want to register in the US, only the US, you go, you do the application there, whatever requirements is needed there. But you will not be protected in other countries. So if you wanna use the Madrid system, the idea is that you pay one fees, you have one application, and you can choose the countries as much as possible to register them. So you can apply for 100 countries using one application and one fees. This is the easy thing.
Yeah, but you should have 100 offices.
No. You register in one of these countries, or you have a residence there. or you have-
وبفكر إن لازم أكون عندي شركة بأمريكا.
Yeah, that's what I'm asking.
No, trying to explain to you. Look, the whole point of the system is I can be in Australia and my business is in Australia, but I want to protect my trademark because the trademark is not, it's very territorial. The protection is territorial. So if I don't register, I will not get the protection of the territory. So I don't need to have an establishment in the US, or I can use the system to establish, to register. It's one gate, it's like a single window. I use the system to the countries where I do business. Even though I don't have to have a company registered.
But you have to first have one of the Madrid or contracted parties also Madrid.
You have the Jordanian.
You have the Jordanian.
Because the Madrid system, so it's not applicable on us.
Well, it's not, it's the fault of the government who has implemented this agreement. But what you can do is that you can go at any of these countries and register your business, if you're a resident or a national of this country, and then you can go for these 124 or more countries.
As we said,
So this is what we were talking about. You have to have a real effective industrial or commercial establishment there, be domestic, or a national member of the Madrid system, which is a contracted party. What they do is that before filing an international application, you need to be registered in an application. It's called the basic mark. The basic mark is that you register your mark in the country that you're residing in, but in addition that it is a contracted party.
So are virtual offices applicable for this?
I'm not sure about that, to be honest.
Thank you. قرب المايك.
When you submit an international application through the IP office, then they will certify and forward it to the Madrid system. And they will conduct a formal examination of the application, and once approved, they will send it to each and every country that you intend to apply to. We talked about the 12 and 18 months, and it is valid for 10 years. I tried to go through it as fast as possible because we are.
You have 5 minutes.
Any questions? Any questions? Any questions to me or to my colleagues?
We have a question. You have a question, Yotta.
Oh, finish for today.
It's not close to the transaction clause. The transaction clause will be not affected unless the both parties agreed on sale. Because if for example, the supplier started to manufacture the goods and even ship the goods, it is not easy for him to buy and terminate the
Correct, that is correct. But what is important, sometimes in the contract, termination occurs without the party just because there is breach. So we can say that if the contract is breaching this application, if the party is breaching this application, the contract will be terminated or will be frustrated according to the jurisdiction that we are referring to. So I agree with what you say. There is no termination. However, there is termination happening when there is a breach. And actually, we can go into detail, maybe now not the right time, of what is a material breach, but some jurisdictions, not all breaches can lead to termination, or whether there is no material breach, it is any breach of any of the obligations. But it is a discussion maybe for another, focus a lot on termination and discussion.
Then the breach should be clear in the contract, yeah. Do not have, yeah.
Yes, this is what I'm saying. Sometimes some restrictions, the breach gets to be what we call major breach, fundamental. In other jurisdictions, any breach of the obligation gives rise to having any business.
I have a question.
Yes.
I told Jordan it's not under the MADRID system. How the state in Jordan will protect my brand?
It will protect it locally, but not internationally. That's the problem. As I said, the issue, like for me, is that Jordan has already implemented the criteria and the requirements. So it only has to now to sign the agreement. The
So
protocol.
why they don't sign?
Because of the COVID.
Let's do that. Let's do that. Any other questions?
Ahmed, thank you so much.